Welcome once again to Lehto's Law. Here's Steve Lehto.
Blois sent me a note and said, Steve, did you see the article on Reason.com about the meat industry? And I said, no, I hadn't. And my first thought was the meat industry. How important could this story be? Well, if you eat meat in the United States and you buy it at the store, this does affect you, or it very well could. Reason.com's article, written by Balin Linnigan, says that the Supreme Court could and should strike down California's animal rights law. Prop 12 threatens the national food economy. Now, that's a broad statement. And you probably know that California is famous for having stricter standards than other states in certain fields. And a lot of it has to do with the way that California is situated, and especially to do with the air quality in Los Angeles. But like, for instance, cars have emission controls. And for years, California has been allowed to have stricter standards than the feds. So you'll often hear about a car being built for the California market versus a car being built elsewhere. But there are some standards that California has that companies just say, you know something, we're not going to build things for two markets. We'll just build it for the California market, and that way it'll be good everywhere. But here's a different situation, but it kind of arises from the same thought process. The U.S. Supreme Court has agreed to hear an important challenge to a terrible, regressive California animal rights law that violates the U.S. Constitution, fairness, and common sense. Now, that's a lot of allegation here, my friends, but it does actually add up. The challenge was filed by the nation's largest pork producers, most of whom may no longer be able to supply pork to the California market due to Prop 12, which is an animal rights law adopted by California voters in 2018. So in 2018, California adopted Prop 12 and said if you sell meat in California, it has to be raised under certain circumstances, following certain guidelines. And if you don't do that, you can't sell it here in California. And of course, the problem is that most of those producers are in other states. And so if you're a meat producer in another state, you have a choice. And your choice is either keep doing what you're doing, just don't sell it in California, or completely revamp your entire system so you can sell your stuff in California. But then the question becomes, does California have the right to regulate how other states operate? Okay? And it's not the states, but it's the producers in those states. At its most basic level, this case concerns Prop 12's targets who are farmers raising livestock outside of California for consumers in California. It also targets farmers raising livestock inside California, but the issue is that most of the meat in California comes from outside of the state, at least with pork, for instance. So California's gigantic population and its impact on the food economy nationally, these regulations affect the rest of the country. This case is also as much about farmers, retailers, restaurateurs, and consumers in Iowa, South Dakota, North Carolina, or any place, as well as California. So Prop 12 was a California ballot measure adopted in 2018, overwhelmingly by state voters, 2/3 almost. The initiative was supported by many of the nation's largest animal rights groups, and it requires the confinement spaces for covered livestock whose meat or eggs will be sold in California must be large enough that the animals, for instance, have room to lie down, turn around, spread their wings, and the law includes fines and possible jail time for violators. So the law actually says if you produce meat under circumstances that are not this good, you face jail time. But what if you're in another state? Can California really jail, a poultry farmer from Michigan? So Prop 12's definition of confined in a cruel manner includes confining a veal calf in a space less than 43 square feet, a breeding pig in a space less than 24 square feet, or an egg-laying hen in a space less than 144 square inches. Sellers of meat and other products made from these animals may be held liable in California under the law if they knowingly sell products, a pork chop, for instance, that doesn't comply with the law. And so Prop 12 will raise prices that California consumers must pay for animal products, but its real impact is being felt outside of the state. The requirements of Prop 12 apply to covered products sold in the state irrespective of whether the products originate from covered animals raised on farms within or outside of California. For example, a breeding pig confined in another state must be housed in compliance with Prop 12 if her offspring will be used for purposes of covered pork products sold in California for human consumption. That's outrageous. It's even more outrageous when you consider that California imports nearly all of its pork. 99.87% of its pork is imported. So, from other states, that is. So, what that means is that when they passed the law on how you raise pork and say you cannot sell it here if it's not raised this way, and you can go to jail, well, 99.87% of it is raised outside of the state of California. And so that makes it that California is now policing the national industry on some level if this law stands. Now, Californians consume around 15% of the nation's pork. Only around 4% of pork producers nationwide currently meet California standards. It's almost as if Prop 12 was adopted to crush the pork market. Thankfully, the U.S. Constitution prohibits such laws. In their suit, the pork producers rightly argue that Prop 12 is unconstitutional because it created dramatic economic effects outside the state and requires changes to the nationwide farm industry that violate the Dormant Commerce Clause. Talk about that in a second. A ruling in the case could have a dramatic impact on other laws around the country, including California's equally unconstitutional foie gras ban and a Massachusetts law that's similar to Prop 12. Indeed, the first case listed in the pork producers' Supreme Court petition is a suit challenging California's foie gras ban. I've written, and that's referring to now to Balin Linnegan. He's written at least as much as anyone else about that case, including many columns in the Supreme Court amicus brief in support of foie gras producers. And it's been supported and signed onto by many other people. He says California's foie gras ban is a primary example of a food or agricultural law that erects unconstitutional obstacles and barriers to the national food economy. But the law does not stand alone. Other recent California laws evidence both a comparable intent and impact. Worse still, other states have begun to follow California's lead, passing laws that pose similar challenges to the existence of the national food economy. This court allows states to prohibit interstate commerce in poultry products and other animal products that are inspected and deemed wholesome, unadulterated, and properly branded under federal law. Then laws like these from California, Massachusetts, and other states could ultimately destroy our national market in food. And so what we're talking about is the Constitution says right in it, Article 1, Section 8, Clause 3, that Congress has the power to regulate commerce among the several states. Congress regulates commerce among the several states. So when it comes to stuff happening between the states, Michigan and Ohio, Ohio and Iowa, Iowa and Michigan, California and Massachusetts, that interstate commerce is regulated by Congress. That is the Congress in Washington, D.C. And so efforts by states to interfere or regulate interstate commerce get struck down as violative of the Commerce Clause. And the Commerce Clause, you don't hear it an awful lot compared to, like, say, the amendments to the Constitution, but it comes up from time to time in business settings. And so what they're talking about with the dormant Commerce Clause is that you can actually look at the phrase that says that Congress has the power to regulate commerce among the several states. Another way of looking at that is, well, since Congress has the power, the states do not. Okay? And so you have to read the Constitution very, very carefully and understand that there's a lot of meaning in how simply some of it's written. So when the original framers of the Constitution said, Congress has this power, they are then, through implication, saying the states do not. Because if the states had the power, they would have said Congress and the states have this power, which they did not do. So by saying Congress has this power, well, the states don't have it then. Congress has it. So if Congress passes a law regulating interstate commerce, they're going to say, oh, well, there they are exercising their rights under the Commerce Clause, Article 1, Section 8, Clause 3. When states try to regulate interstate commerce and someone steps in and goes, you can't do that, you can't do that because of what they call the Dormant Commerce Clause. And the Dormant Commerce Clause is actually the implication of the Commerce Clause, that because this right is reserved for Congress, it cannot be exercised by the states. And as you can imagine, like I said, this problem, we're aware of this with the situation with automobiles. And you might say, Steve, how does that work? Remember that Congress agreed a long time ago to let California do that. So while California has its own standards, for instance, on tailpipe emissions for cars, or at least it did for a long, long time, they didn't just wake up one morning and do that on their own. They got the permission from the federal government to do it because they had to. And the federal government said, California, you're special because you've got such a problem with smog in Los Angeles, and we're going to let you guys do this. So California has higher standards on tailpipe emissions, and they didn't do it unilaterally. They did it with the blessing of Congress. And so that's how you get the Commerce Clause proactively saying that Congress can regulate interstate commerce, and the Dormant Commerce Clause, which is the implication that states therefore cannot. So the idea that California with Prop 12 can say, here's how we want to handle the sale and so on of meat in our state, well, they can do that within their state. But the second their regulation appears to dictate how things are being done in other states, well, there's a strong argument to be made that's a violation of the Dormant Commerce Clause. So we'll see what happens. And what's interesting about a story like this is the law got passed in 2018, but as with many laws, it doesn't go into effect right away. And so apparently it's going into effect soon, or maybe it's already gone into effect. But the point is that right about now, it's coming to a head with people seeking SCOTUS review, Supreme Court of the United States, to review this and see what they'll do about it. And this one's hard to say. It's hard to say. If I had to guess, I think they'll strike this down. Because if they don't, you can imagine what's going to happen, because all the pork producers are going to go, well, even though they're a big part of our market, to comply with their stricter standards, it's going to drive us out of business. Here's what we'll do. We'll just simply make our stuff and just say not for sale in California. Not for sale in California. And then what's going to happen is the price of bacon in California is going to skyrocket. And you're going to have some very, very upset people. And we'll see what happens then. So, Blois, thanks for sending it. And SCOTUS could and should strike down California's animal rights law, written by Balin Linnekin. Proposition 12 threatens the national food economy, from Reason.com. Questions or comments? Want to blow? Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I'm still mad at my classmates for voting me most likely to hold a grudge.